Hello, this is Professor Rajyalakshmi. I'm a teacher of international law. Belated New Year greetings to everybody. I know how eager we were all to push away the year 2020 from our lives because 2020 was the year which threw on us a huge pandemic bomb, even while it was in the womb of the year 2019. So, having gone through a miserable experience of almost the entire 2020, here we are all getting ready to travel through the year 2021. And our journey into this year 2021 is bound to be a journey of reflections. Reflections on the multiple and multifaceted experiences which arose out of COVID crisis. Well, I have, in this context, I have identified three COVID generated necessities to reflect on as a teacher of international law. The first one is the necessity to transform to be an online teacher. The second one is the necessity to add pandemic specific content into the teaching of international law. The third one is to take COVID-19 as a reference point for international legal research. Well, 2020 would successfully transform all of us to be online teachers. And in this process, we did encounter quite some transitional difficulties. But I feel that so far as these transitional difficulties are concerned, I don't consider that the teacher of international stands in a better position or in a worse position when compared to teachers hailing from the field of other teachers hailing from the field of humanities. On the other hand, I see a beneficial dimension in this compulsive shift to online method of teaching. Well, I'm speaking from the point of view of third world teachers. The first and foremost advantage is that because of this compulsive shift, most of the third world teachers could overcome their digital difference because there was no other alternative. And even with reference to those teachers who are otherwise, they're reasonably familiar with digital, with the use of this digital technology. In pre-COVID times, they were rather found to be complacent in making use of this cyber medium to acquire wider reach to their teachings. Now that the online mode of teaching or discussion has become a regular form of activity, I feel that there are at least some third world teachers who are stimulated enough to use cyberspace to gain a much wider consumption to their teachings, which I feel that so far as teachers of international is concerned, they are going to be benefited more by virtue of this stimulation, provided that stimulation is converted to be action. The more than these two advantages, in fact, I see a long-term advantage. There is the general criticism regarding the teaching of international that essentially it proceeds with a Eurocentric approach. Keeping in mind this criticism, if the third world teachers indulge in utilizing this cyber medium for their teachings or for their discussion, if they utilize this cyber medium to critically evaluate international law from the third world perspective, I feel there's a long-term gain for the third world community in acquiring third world content, character, or complexion to the teaching of international law. This is what I positively believe. Well, so far as the second need is concerned, it is about the need to add pandemic specific content into the teaching of international law. We know pretty well that the COVID situation has raised many questions of theoretical importance and practical significance. And these questions obviously need to be answered from international legal perspective for the simple reason that pandemic has got an international character and it carries international consequences. Uh, and therefore, as a teacher of international law, number of questions are being faced by the teachers of international law in the backdrop of COVID experiences, and it is therefore the range of questions are such that questions are coming from commoners purely out of curiosity. Questions are also coming from fellow specialists in order to have a critical examination of the issues at hand. So, for all these reasons, it's very important for the teacher of international law to develop pandemic specific questions. Like I can give you just one or two examples of these questions. Queries are being made about the very role of international law, whether international law has got any role to play in the surveillance of communicable disease across the world. And questions are there regarding the international responsibility of China for its alleged concealment of eruption of COVID-19. Questions are there regarding the position of vulnerable groups. So there are many pandemic specific questions that are to be addressed by the teachers of international law. Questions might even be, obviously you can expect a lot of questions from the students. So therefore my appeal to the teachers, young teachers of international particularly, is that we need to develop that pandemic specific content even for senior teachers. And I can tell you that with as a teacher of international law with the adequate experience, I'm 100% sure that pre-COVID teaching of international has hardly any content of has it never had any content of pandemic specific content. And of course, there's nothing to feel regret about it because you can't expect the teachers to keep every possible situation in contemplation and teach accordingly. That is not expected from teachers. But now that this is the current situation, this is a contemporary situation, it is necessary for the teachers to get themselves up, to equip themselves, to get themselves up with the knowledge of pandemic specific issues, and then be able to effectively answer these questions, whether they might be from a commoner or whether they might be from a student or whether these questions might be from fellow specialists. So there is an absolute necessity. Of course, this I mean in all probability this requirement is going to be only a contemporary, like a provisional requirement, maybe for the time being, because in course of time obviously there is this hope that with medical solutions that are coming forth, we will be able to overcome this pandemic situation. And so therefore the requirement of having to having to add pandemic specific content into the teaching of international law, it is going to be a short term requirement. But let me tell you that the experience of COVID-19 is so huge that for some time to come, teachers of international law will be haunted with questions in the backdrop of COVID experience. So I appeal to the teachers of international law. The basic appeal is to the young teachers of international to equip themselves to with the pandemic specific content while teaching. In higher education, research and teaching, they go hand in hand. They ought to go hand in hand. And COVID situation is one situation which provided a deep emotional instigation to seek point specific investigation into variety of issues raised by the COVID pandemic. In other words, it demands research on all questions which are pertinent to COVID situation. In fact, deeper research is required on issues of categorical importance. And when I'm insisting on research, I'm not really insisting on the production of doctoral works or postdoctoral works or publications in reputed journals by meeting all formal specifications. Not that they're of no use. In fact, extensive works of research have an immense importance. There's no denial of that fact. But at the same time, one should also remember that small research notes, provided it is well founded, it has lot of importance in aiding the teacher of international law to explain the issues with greater authenticity. Apart from that, if these well founded notes may be consisting of certain observations, certain findings, or certain lines of thought, well, if these well founded research notes, even if they are in an informal form, no, we're not meeting any formal specifications such as well documented with all that good documentation and all that. Even if it is in a very informal way of jotting down one's own thoughts, if these thoughts were to be kept on online domain, this has the added advantage of exposing the varied lines of thought for critical evaluation, where they're kept on the online domain for peer consumption or for general public consumption. I think these thoughts are likely to get critical evaluation, and in the process might contribute in a better and a better transformation of international law. So far as public health is concerned, uh, research on issues of COVID, I feel, is a definite opportunity to build up the edifice of international law concerning public health governance. This is how I look at the need for conducting COVID specific international legal research or pandemic specific international legal research. Of course, it is not that it's not just meant for developing pandemic specific jurisprudence, but rather this is something should have a wider framework of looking at the overall issue of public health governance under international law. And to my mind, there are number of questions. Only, of course, let me tell you that they are only illustrative. There are a good number of questions which deserve detailed examination. Say, for example, take the case of the cross dynamics of public health responses vis-a-vis the enjoyment of individual human rights. Questions are there regarding, this is one situation which raised very, what to say, very serious questions or very brought into line such heated questions on uh, the questions of under responses of the countries, over responses of the country, or inappropriate responses of the country, and issues were raised regarding the proportionality of the public health measures, regarding the lack of reciprocal arrangements where public were expected to comply with public health measures, uh, compromising upon the enjoyment of their human rights, not having any reciprocal arrangements is one issue. And questions are also there regarding the misuse of these public health responses for other purpose, primarily for political as a political opportunism. So these are all heated questions. So all these issues they need ground level examination in a detailed manner in the light of and doing it in the light of international law. Examining the ground level issues, but analyzing them with an international legal perspective. So issues such as this, they need a detailed examination, say in the backdrop of Siracusa principles, in the backdrop of 2016 draft of International Law Commission on the protection of persons in the event of disasters to 2016. And research in COVID background is not just meant to provide legal insights into just the current crisis. But when we take into consideration that you cannot rule out recurrence of pandemics because of the climate insecurities, it's important that uh, the research should have a futuristic perspective. Another pandemic might recur of a different kind. If not a pandemic, there could be another public emergency, health emergency, whatever it is. Therefore, I feel it is crucial for the young teachers and researchers of international law to explore current issues with even the experienced teachers to explore the current issues with futuristic approach. Now, as I see, there is now a greater need to indulge in comparative and interdisciplinary research and interpolate this research with the law of public health governance under international law. Research on, say, the problems or prospects or dilemmas or institutional experiences in addressing the health emergency pandemic situation, it goes a long way in critical evaluation of international law concerning public health governance. Say, collection of data to map out the lessons learned or to map out the best practices adopted across the world. They will be of great help for two reasons. First is that, as I told you, there could be there you cannot rule out the occurrence of another pandemic, if not immediately, at least after quite some years, whatever it is. So this would be of great help in better handling of pandemic situations. Number one. Secondly, it will also have a current relevance of helping those international organizations who are already coming out with post COVID recovery plans. So, uh, in working out, in better working out of this post COVID responses. Now, COVID opportunity, this COVID crisis also provides an opportunity for us to censure the failure of the United Nations to declare formally to declare this as a threat to international peace and security. Maybe there are political reasons, I'm not going into that, but then this is an occasion to insist to do research on that and to emphasize the importance of the need to take such non-traditional threats such as public health emergencies as a what to say as a threat to consider that as a threat to international peace and security and bring it within the mandate of R2P, responsibility to protect, and also detailed analysis into the scope and limitations of international health regulations, and an objective analysis of the role of World Health Organizations. Particularly, one can examine in detail the reasons for the failure of the World Health Organization in timely issuance of public health emergency declaration. The you can address the problem of the ambiguity prevailing in the parameters which are to be considered in declaring public health emergency. So all those things need to be researched upon so that the research would pave ground for uh, good reforms in international health regulations and also in strengthening the role of World Health Organization. This is again a matter of this again is an issue of importance for the future, and perhaps it would also be a very interesting exercise to indulge to examine what would have been the response of the International Court of Justice if the World Health Organization was to invoke the advisory jurisdiction of International Court of Justice regarding the the failure of the China in bringing to its notice, immediate notice, the occurrence of viral attack in its territory. Also, special studies should be conducted on the extra adverse impact upon vulnerable groups such as women, like who were exposed to a lot of domestic violence during COVID times, problems of refugees, problems particularly of migrant workers. The studies on exclusive studies on these vulnerable groups, definitely they help significantly in strengthening the argument for developing COVID recovery plans with an inclusive approach. That is one constructive purpose such special studies would have. Another area of concern is the dilemma of maintenance of ethical norms during emergency situations which demand quick solutions. So I think this is something it deserves attention of the scholars to develop the case for framing up a common minimum code of ethical research in times of public health emergency situations. This is very very important, because to what extent, what is the I mean to what is the basic limit beyond which one cannot compromise, maybe as a matter of coming out with a quick medical response, but beyond something beyond a particular level, the ethical norms cannot be compromised. Or if they have to be compromised, what precautionary measures that have got to be taken, what kind of regulatory framework that needs to be kept in place. So all those issues need to be worked on. Well, of course the list can go on. And while emphasizing on the need for COVID crisis focused research, I feel that there is an absolute need. It is time that the scholars should try to explore and try to develop a case for creating new space in international law to meaningfully accommodate the public health concerns, maybe with particular reference to pandemic, or even in a or in the case of any other public health emergency. So it's very important that the researchers will have to engage oneself. The researchers have to engage themselves in this kind of exercise. For example, keeping in view the cross cuttings of international trade policies and the public health concerns, I feel that it is high time that we should try to explore the potential space for in international law to impose mandatory duty on the corporate actors for assuming participatory responsibility in the management of international public health crisis. So, substantial argument. I think it's high time that a substantial argument could be made out, say, for creation of avenues. Like, say, for example, demanding that making a case for compulsory sharing of the costs of research research and production and equitable distribution of vaccines, or maybe providing medical health and other support during or little after the crisis situations, and based upon the appeal based on the consideration that after all corporate actors are the basic beneficiaries of the international trade policies. So it is high time that space will have to be explored to see that non-traditional actors like corporate actors also should become the bearers of international duty so far as management of public health crisis is concerned. And COVID pandemic also has brought into limelight the vulnerabilities of a special section of people, uh, the section which was not recognized hitherto. I'm talking about the medical professionals. Medical professionals. So we have witnessed how extensively the services of the medical professionals, including the paramedicals, have been extensively used beyond optimal limits. Beyond optimal limits. And we know there were many countries in which doctors, on one hand, they were fighting against the COVID-19 as barriers. At the same time, they were also struggling with inadequacy of infrastructure, lack of medical personnel, and there were a number of countries in which and countries and even within the countries where there were a number of situations where medical personnel, paramedical personnel, they were lending their services without a protective gear for themselves. In other words, they have kept in jeopardy their own right to life and their own right to health. In addition to that, we also heard of instances where they were attacked, they were subjected to attacks, physical attacks, they were discriminated, all because they are most intimately connected with fighting the COVID crisis. They were looked upon as agents of communicable disease. So that means they are exposed to, they have become extreme vulnerable group in that situation, in a pandemic situation. So I think it's very important that we have to work out, we have to appeal through the research of the need to identify this personnel and other frontline barriers to create a space in international law for their recognition as special vulnerable groups during the public health crisis of this kind, particularly during pandemic kind of problem. So I mean, this is how we have to find the new space under international human rights law. And another area of research I would recommend is on the issue of international institutional collaboration during health emergency situations. During crisis situations, collaboration means a lot. It means a lot. So, studies will have to be conducted as to if any efforts are made by the intergovernmental organizations or even by the international non-governmental organizations regarding institutional collaboration. You know, institutions definitely they were responding in their own way, but whether any efforts are being made at collaborating these efforts, which means a lot of, which makes a lot of difference. This is something like which helps a lot in very effective management of health crisis. So it's important that taking into account the various experiences of the intergovernmental organizations and then coming out with a model plan only for collaboration, model plan for collaboration amongst the institutions, both formal as well as informal organizations. If we come out with a model plan which could be put to use in future emergency situations, I think this again is going to be a contribution of immense importance. Where because economic and social council, since it is the center of coordination so far as the work of the specialized various specialized agencies are concerned, where under the umbrella shape where the plan had to be worked upon and certain some say something like carrying out trying to coming giving some suggestions on various ways in which the collaboration could go about. So where the research helps in coming out with the provisional plan that can be put to use with some variations depending upon the individual health emergencies. I think this is going to be of immense importance. So finally, I conclude by saying that COVID situation has provided us a lot of food for thought. It is it is now our turn to consume this for developing good to develop an insightful understanding of international law so far as public health governance is concerned, and also doing our best to lend juristic direction for the transformation of international law for the better. Thank you.